using a simple and colloquial language, we will address the main aspects related to the testamentary successions. In the next episode, we will focus our attention right on the wills. Today, however, we will specifically examine the position of the heirs in this type of successions. And now, let's see our clip.
When a testamentary succession occurs, heirs and legacies are those who are chosen, and indicated as such, by the testator. However, the freedom of the latter to choose his, or her heirs and legacies, is subject to limitations. In fact, the Italian law provides that there are some heirs entail, that is to say, some people who, due to the particular family relationship that binds them to the testator, are anyway entitled to receive a share of his or her inheritance. The entity of this share, and the subjects who are entitled to it, are established by the law itself. Such particular heirs entail are defined as forced heirs.
At the basis of the particular inheritance rights, recognized to the forced heirs, and which the testator himself cannot violate, there is the recognition, by the Italian law, of the importance of some specific, particularly close, family relationships, and the will to give protection to such relationships. This means that, even if the testator had excluded one or more of the forced heirs from his or her will, or had attributed a lower share of the inheritance to them than that provided for by the law, these particular heirs, in the 10 years following to the opening of the succession, can take legal action to obtain the reinstatement of their inheritance rights, that is to say, the attribution, or the adjustment, of their share of the inheritance, over the deceased's estate. But, in concrete, who are the forced heirs? Article 536 of the Italian Civil Code establishes that the forced heirs are exclusively the spouse, children, and legitimate ascendants. And what inheritance shares belong to these subjects? Well, even in this case, the law sets a series of hypotheses in relation to the fact that there are, or not, two or more of these subjects.
In particular, when only the spouse, or, alternatively, only the child is the forced heir, they are entitled to a reserved share, equal to half of the inheritance. If, on the other hand, there are exclusively two or more children, the inheritance share reserved for them is equal to 2/3 of the deceased's estate, to be divided between them in equal parts.
Where, differently, there is the concurrence of the spouse and only one child, each of the two will have, as forced heirs right, a reserved share equal to 1/3 of the estate. On the contrary, if, in addition to the spouse, there are also two or more children, the former will be entitled to a reserved share, equal to 1/4 of the deceased's assets, and a further half will be due to all the children, in equal shares.
In the hypothesis, then, that the testator's only forced heirs are his ascendants, that is to say, the father and mother, or, missing them, the grandparents, they will be entitled, as forced heirs right, to a reserved share, equal to 1/3 of the inheritance, always to be divided among them into equal shares. Finally, if there is concurrence between the spouse and the ascendants, the former will have a share, equal to half of the inheritance, and a further 1/4 will be due to the ascendants.
The remaining portion of the hereditary estate, following to the attribution to the forced heirs of their shares, is defined as disposable part of the estate, and, with respect to it, the testator is not subject to constraints, and is therefore free to dispose of it, as he sees fit.
Therefore, as we have seen, the heirs entitled to a reserved share have a position strongly protected by the law due to the particular family ties that bind them to the deceased. This is such an excessive protection that Italian law states not only that the aforementioned heirs cannot be deprived by the testator of their inheritance right on the reserved share, to which therefore they are always entitled, but also that such inheritance rights cannot be subject to conditions, terms, or moduses. However, it should be borne in mind that, if on the one hand, the heir entitled to a reserved share always has the right to receive such reserved share due to him, the latter on the other hand has no obligation to acquire it. In fact, he or she can always renounce the inheritance. In the same way, if the testator has excluded such an heir from the will, or has attributed a testamentary bequest to him or her that is lower than that stated by the law, the latter will be able to obtain his or her inheritance right on the whole reserved share that belongs to him or her, only on the basis of a judicial decision issued following a civil judgment. Attention, such lawsuits are long, expensive, and in most cases during the trial the hereditary assets remain blocked, and this might produce damages upon all the heirs. As an alternative to the judgment, when the situation allows it, the appointed heirs and excluded heirs in tail can re-establish the inheritance shares provided for by the law in favor of the said heirs entitled to a reserved share by stipulating before a notary a restatement of the reserved shares deed. Such deed must, however, be carefully calibrated to satisfy all participants and to avoid possible future problems. Also, this episode has come to an end. Thank you for joining us. If you want to be informed about the next videos we will broadcast, do not forget to subscribe to our YouTube channel or to follow our Facebook or LinkedIn page or our Twitter account. I'll be waiting for you next Monday, always at 5 p.m. Rome time, always in live streaming on our YouTube channel, to start talking about the will. Thank you, and arrivederci.